response? Any response? At this time, I will deny the motion. Is there anything else we need to discuss prior to bringing in the jury? Any response? Any response? At this time, I will deny the motion. Is there anything else we need to discuss prior to bringing in the jury? Any response? Any response?
Thank you, Josh.
You'll probably be happy to be back in front of Judge Sarah.
That's not people there. It's been quick.
What's that?
All rise.
Everyone can have a seat. Ladies and gentlemen, I have made a revision to the jury instructions. If you can turn to page 7, and I'll direct you to the third complete paragraph where the defendant maintains after Casey Gooden posed an immediate threat of serious physical harm was included. I failed to have that in the prior jury instructions. What we're going to do today, we're going to have closing arguments this morning, and then you'll retire to deliberate. Are there any closing arguments on behalf of the state of Ohio? Let me get this live stream up on my.
May it please the court, counsel, ladies and gentlemen of the jury. 6 shots in the back. No matter how Mr. Collins and Mr. Nolder twist and turn, it is still 6 shots in the back. Now, we talked in voir dire about burden and standard of proof, and the state had the burden to go forward with evidence to prove by a standard of proof beyond a reasonable doubt, the charges of murder in count 1, murder in count 2, and reckless homicide. I submit to you, ladies and gentlemen, that we have done that. We have shown that on December 4th, 2020, in Franklin County, Ohio, the defendant purposely caused the death of Casey Goodson Jr. We've also shown that on or about December 4th, 2020, in Franklin County, Ohio, the defendant caused the death of Casey Goodson as a proximate result of knowingly causing serious physical harm. You've heard the instructions of the judge. Knowingly causing serious physical harm is the offense of felonious assault, which is a felony of the second degree. And when that is the proximate cause of death, in Ohio, the crime is murder. We have also shown that the defendant recklessly caused the death of Casey Goodson Jr. There is no real argument that exists that the state did not meet its burden and did not reach its standard. Now, we heard time and time again, well, you know, when a police officer shoots at someone, he wants to stop the threat. Stop the threat. That, we heard it, you know, Mr. Collins elicited it from pretty near every police officer that testified. You heard Mr. Davis say, yes, it's to stop the threat, stop the threat. And somehow the implication is that when you point an assault weapon at an individual and you fire it 6 times, either on automatic or semi-automatic, at center mass, the vital organs, that there's no purpose to kill. But you've heard the judge's instructions. Purpose means it's not accidental, it's intentional. You did it on purpose. The instruction tells you that when you use a deadly weapon, and that, ladies and gentlemen, is a deadly weapon, on someone, you may infer purpose. You don't have to, but you may. And I submit when you're 10, 12 feet away from your target, when you've got a sighted in on the vital organs of the center mass, and you discharge that weapon 6 times, 6 bullets, purpose to kill is there. Certainly knowingly causing serious physical harm is there. Knowingly is a slightly lesser standard than purposely. But when you point a gun at somebody and pull the trigger, you are out to cause harm. So if somebody gets up here and tells you, oh no, just wanted to stop the threat by purposely causing death, by knowingly causing serious physical harm, or the last mental standard, reckless, which is the lowest of the 3 mental standards, talks about heedless indifference. point a gun at somebody, heedless indifference, pull the trigger, that's reckless. That's knowingly, and that's purposeful. So I submit to you that there is no valid argument on any of the elements that the state has to show to prove the charges that have been lodged against the defendant. I hesitate to say this, but it's almost like it's beyond all doubt. Does anybody have any doubt as to how Casey Goodson died? He died from 6 shots from the defendant that the defendant acknowledges he fired, that even without the defendant's acknowledgement, and Caleb Worley come in, he looked at the 6 shell casings that were collected. He looked at the 5 bullets, spent bullets, that were collected either from Casey's body, or that were collected at the site of this, out of the wall of the kitchen, out of the microwave in the kitchen, off the floor of the kitchen, and he compared them, and he told you they were fired from the defendant's weapon. So let's get to what this case is really about. Remember back in voir dire, I talked about the different ways that you defend a criminal case. The Sodai defense, some other dude did it. Doesn't come into play here. There is no question who the participant in this case are. And then the defense of, what is it? Is it a crime? Is it not? Again, the elements are all established, but we have a variation on a what is it, the yes but, the affirmative defense of justification. That's what the defense has raised. And let me remind you, it's their burden to prove that. It's not our burden. It's their burden to prove it. And they've got to prove it to you by what we call a preponderance of the evidence, the greater weight. Put very simply, if you balance all the evidence and it's a tie, they lose. They didn't sustain their burden. They didn't reach the standard that their burden requires. And you have the definition for the justification defense. It's a complex one, and not easily understood, and gives latitude to police officers, which they should have. They're doing a dangerous job. They're in dangerous situations. They should have some latitude. They can be mistaken, and a honest mistake, shouldn't be held against them. But remember, this is not what the defendant thought to establish the justification defense. It is what an objectively reasonable officer standing in the shoes of the defendant would have concluded and what action he would have taken. So just because Mr. Meade says, I had to do this, you don't have to accept that. Not if, looking at all the evidence, it doesn't make sense. Because if you look at all the evidence and it doesn't make sense, then an objectively reasonable officer with proper training would not have fired shots, would not have killed Casey Goodson. Now, the defense brought in an expert to help you. We brought in an expert to help you. You'll have to decide who to believe, because I think you saw very contrasting presentations from the experts. You saw a retired officer, spent 30 years, about half of it training other officers on various things, not just use of force, who said, you know, if you got a hunch, you know, if he could have caused harm, you know, there's the risk. He had to stop the threat. What threat? There was no threat. And then you had Professor Stoughton, who granted what hasn't been a police officer, or I mean, he has been a police officer, but he hasn't been one for 30 or so years, who talked to you about the practices and principles and how they've developed and how they try to train and teach officers and so forth. And freely acknowledged that, yeah, you know, somebody with a gun is a threat. But is he an imminent threat? Is he an immediate threat? Do you take the kind of action that the defendant took? And he walked you through the actions of the defendant that day. You know, he told you about, you know, we train police officers to create time, not to minimize the time. You know, distance is your friend. He's got a long gun. He's got a long gun that he's taking on. A handgun. Who's got the advantage? He doesn't have to be 12 feet away from it. Could have been 20 feet away. Could have been 100 feet away. Been out to the site, you know the distances involved. Elmo, please. Right there. Doesn't need to close the distance any closer than that. You could have been standing behind the tree, position of protection, cover. Doesn't need to be up there at the gate. He could have effectuated everything right from there. But instead he closes the gap. And, you know, we all chuckled yesterday when Professor Stoughton was questioned about the pants on fire fella. You know, yeah, he closed the gap there. Why? because the man's pants were on fire. Casey's pants weren't on fire. No reason to go any closer than that. So, as you look at the evidence, and as you consider the viewpoints of the experts, who are you going to listen to? Who seemed to be an expert to you? Who educated you about police practices, about how police analyze situations? It was very analytical, very logical, and one that showed you how a well-trained police officer, an objectively reasonable police officer, can do things to protect his safety and minimize the risk to others. We heard the defendant's philosophy. I hunt people. I throw the first punch. Here he fired the first shot. Not only the first, but the second, the third, the fourth, the fifth, and the sixth. 6 shots in the back. I throw the first punch. That's not what they're trained to do. That's not keeping himself safe. That's not keeping others safe. That's murder. You heard Professor Stoughton, and he told you over and over again, despite being asked to resolve factual conflicts, that's not my job here. My job is to come in here and tell you about police practices and how a well-trained, reasonable, objectively reasonable police officer should act. When there are factual conflicts, that's your job. Did you hear that from Kevin Davis? Did you hear him say, oh yeah, there are discrepancies here. I mean, my goodness, the defendant says that he turned and shot him, but all the shots were in the back. Meaning Casey's back is to the weapon when it's fired. Did you hear him say, that's a dilemma here that you, ladies and gentlemen of the jury, will have to resolve? No, he didn't. He said the defendant acted appropriate all the way through. He accepted carte blanches the defendant's explanation. He didn't give you what a objectively reasonable officer would do. He gave you what the defendant did and said, hey, it's all right. He was an advocate. He wasn't an expert. He was in here telling you why, the defendant acted properly. He was advocating. That's not the role of the witness. The role of the witness is to give you information. the advocates are all sitting at the tables here. Take that into account when you evaluate his testimony and you evaluate his conclusions. And you make a determination as to whether he supports, that his testimony supports what they are required to prove. Now let's talk about the evidence. There's a hard and true fact in nearly every criminal case. You have to determine the credibility of the witnesses. Just because somebody got up there, raised their right hand and promised to tell the truth, doesn't mean they did. But let me tell you something. Physical evidence doesn't lie. It doesn't have a credibility test. It is what it is. Physical evidence doesn't lie. People do. And I submit to you that one of the first things that you want to look at in evaluating the credibility of an individual is how it compares to the physical evidence. Because physical evidence doesn't lie. People do. You want to look at motivation. Who on that witness stand had the motivation to be untruthful? You'll have to decide. Was it Sharon Payne? We need to go to the computer. You heard her testimony. You heard the agony of that day. Did she strike you as being deceptive? Did she sound untruthful? Because the other thing you heard was her calling 911. And I want you to listen to it now.
911, what is the address of your emergency?
3996 Estates Place.
And what's the emergency?
My grandson just got shot in the back when he came in the house, and I don't know if he's okay because it's still out there.
I'm sorry, what just happened?
My grandson just got shot
Okay, where did this happen?
at my house. He lives here with
Okay,
me.
so who shot him?
I don't know. I just
Okay.
heard the gunshots, and I would get up, and he's laying in the door.
Okay. And nobody saw anything prior to this?
No, he went to the dentist or somewhere and came home, and all of a sudden I had a bunch of gunfire. He's not a bad kid. He's done have a police record. He works. I don't know what happened.
Okay, is there anybody in the house that can tell you who shot him?
No, they don't know. They were threatening everybody in the house. I don't know what the fuck's going on.
That's okay, we've got help headed that way. Did they say if anybody was outside arguing with him or anything?
Pardon me?
Is he breathing?
I don't know. They won't let me in the kitchen by him.
Okay. Did he say if he had, like, any disputes with anybody?
No, not that I know of. I'm not aware of anything.
Okay, what's your name and telephone number, ma'am?
Sharon Payne.
Okay.
614-597-5570.
Do you know if he was dropped off by anyone?
No, he went to the dentist or somewhere. He was driving my car. I don't know what happened.
Okay.
I don't know what's going on.
All right. Well, the officers
There's a
will
black
be
guy
that way.
out here waiting.
I'm gonna go ahead and get the medic started that way, okay?
That's the damn police. Hold on.
There.
Give
Okay.
me that squad.
Ma'am?
That's the police.
Yeah, the police are there, and they've got the medics too, okay?
Why did you get them up?
Grab a concrete dog. We need everybody out of the house.
Don't have a problem.
Okay, everyone out of the house. Grab your kids.
Inconsistent with her testimony? I don't think so. That's as it was happening. Got the storm door. What do we know about the storm door? Well, there was glass in here that got knocked out from the defendant's shots. Three bullet holes. And the way the bullet or the screen is bent, Amy Culia was able to tell you the trajectory of these three shots. You'll have her diagram back there. We have a nick up here, another bullet. In order for, we know that Casey was inside the door. Defendant told you that. Makes it kind of difficult to turn and face the defendant with a door between them. We know the inside door is open and undamaged. So none of the shots hit it. It was open when the shooting occurred. And guess what's in the inside door's locking mechanism? Casey's keys. He'd unlocked the door. He'd opened the storm door, unlocked the inside door, and had swung it open enough that it was out of the range of the bullets that struck him and passed through him and passed through this door, because all the bullets passed through this door. It's just happened to have this screen to protect, probably because of the big dog. That's the only reason that we have what we have there, because all the glass was, and you'll see it in the pictures, all the glass is on the ground. It's shattered in small granules. I think they make glass that way so that you don't have the sharp pieces that cut people and stuff. Physical evidence doesn't lie, ladies and gentlemen. People do. What else does the physical evidence tell us? We got Casey's gun. This is the safety on the gun. Safety is off when it's down so that the slide can move. Safety is on when it's up. When crime scene search unit documented the scene, one of the photographs they took, and you'll have it back there, although it's difficult to see on the printed photograph. The gun. Josh, were you there? Where the circle is, that's where the safety is. It's not down, it's up. So what's that tell us? It tells us that Casey had the safety on in his gun. You're gonna shoot someone, you take the safety off. Otherwise, the gun won't shoot. When would you have the safety on? When the gun's in the holster, because you don't want to shoot yourself. And you're not going to shoot it while it's in the holster. And this is the holster. Pretty flimsy. So you decide. Did Casey pull the gun out of his holster and turn and point it at the defendant with the safety on? Or perhaps it never left his holster until after he was shot. Remember, there's an extended clip in here. You can't put it because they've made the gun in such a way, thankfully, that it's very safe, can't be fired, but it had an extended clip, which makes an extended loaded clip, which makes the grip part all that much heavier. And you heard from Detective Hughes, I wouldn't have a holster like that. You know, why not? They'll fall out. There's no restraining strap, nothing to hold the gun into the holster other than your body in the holster. So it's not hard to imagine, as Casey fell, the gun falling. And where would you expect the gun to fall? Right where it was found, under his torso, under the right side of his torso, right where it was found after he was rolled over. Physical evidence doesn't lie. People do. We got AirPods, and you'll have the AirPods back in the jury room. Here's where they were documented laying on the floor after the medics had removed Casey. And after the medics, remember Kyle Lighthizer told you, yeah, they were in his ears. As I was assessing him, I'm doing an assessment, I took them out of his ears. This is his dew cap, like a skull cap. What do we know about the AirPods? Well, we know from Casey's phone and Detective Howe that they were connected to his phone. We know from Google records and YouTube music that during the time this all happened, music was playing. And I know the defense is going to say, well, we don't know how loud. We don't know how loud it was playing. You know, and we don't. But we know it was playing. We know they were in his ears. We know that when AirPods are in somebody's ears, and depending on the volume, and I don't have AirPods, you've seen my technological skills. I don't know how to operate them. I don't know how to use them. After I turn the computer on, everything else I have to call my 7-year-old granddaughter and ask her how to do it. But how many times have you had AirPods and didn't hear somebody talking to you? How many times have you had to shake someone who was listening to AirPods because you wanted to get their attention? Physical evidence doesn't lie. People do. We've got a bag of Subway sandwiches. Sorry, I'm just going to switch back on you here. And here's Casey carrying the bag, heading to his car. Just bought them. 3 subs. You'll have the receipt. Here's where they ended up, on the floor of the kitchen. Right between the stove and the refrigerator. Not underneath him, because he was carrying them in his hands. Not underneath him. They're off to the side. Physical evidence doesn't lie. People do. So let's imagine, or let's process all the things that were going on at the threshold of Casey's home when he returned that morning with the sub sandwiches. He's got the subs in one hand. He's got a pretty bulky set of keys, and you'll see that. Didn't pull the picture, but you'll see the keys hanging in the door. We know he's got the Subway sandwiches because we see him there at Subway shop, and we see him on the kitchen floor. The only way they get there is somebody transports them, and Casey's the only one to transport. We know he had the keys because the keys are there to unlock the car, unlock the door. And on that set of keys is the car key. It's right above the little Mickey Mouse statuette. So he had to transport the car keys that have the house key from the car to the back door. So, one hand, Subway sandwiches. Other hand, keys. I submit they're probably in his right hand because he's right hand dominated, but more importantly, the lock and the door, the handle to the door are on his right side. Gun. Well, we know he's got the gun. It's out of hands. Where's the gun? The gun's in the holster, in his waistband. Kyle Lighthizer told you, I saw a holster in his waistband. Officer Rosser told me, I saw a holster in his waistband. Subway sandwiches, keys, gun. What's he turning point with? The Subway sandwiches? 6 shots to the back. Not the front, not the side, but the back. His back is to the shooter. Professor Stoughton told you, yeah, of course somebody with a gun is a potential threat. A potential threat. But we don't have our police officers acting on potential threats. What happens when they act on potential threats? Exactly what happened here. And that's not justification. That is not justification. Now let's talk about shots themselves. This, I guess we need the bottom here. This is the diagram that Dr. Shepler prepared based on her findings in her autopsy. And it's showing the upward trajectory of each of the bullets. Because they all were going upward, none of them were going down. We got the 3 in the upper back. Now, we're gonna hear, well, wait a minute, that's all based upon standing up straight. Well, yeah, they've got to have some metric to measure off, and to set it forth. And people aren't necessarily standing up straight. They move, they twist, and so forth. But what can we tell from this? I submit to you, ladies and gentlemen, that the first thing that stands out is that the 3 shots in the upper back, the ones that did the most damage, were the first shots. Because though Casey may not have been standing straight upright like this in the diagram, he was more or less in that position. And they all have very similar upward trajectories. But let's look at the lower shots. And what does that tell you? Well, you know, your body has a pivot point right around the waist. And so as you bend, a shot that would normally pass through you at the upward angle that you see in the upper shots gets a sharper angle because it's coming in as you are bending. If it's below the pivot point, you have a bit less of an angle. But here, we have a sharp angle that's right above the pivot point. We have the shot in the buttocks that it has a lesser angle. And then we have the gash in the side that has a sharp angle. Consistent with falling. Consistent with falling. And if the first 3 shots are the upper back, what are they going to cause? Falling. So, I'm sure we're going to get some demonstration again of twisting and turning and getting the ruler out and so forth. But what makes sense here? What makes sense? Now let's talk about the timing. Because if, as the defendant claims, Casey has turned his body to point the gun, he has to have turned it all the way back, pretty much square to the shooter, before any bullet strikes him. Does that strike you as reasonable? Did they establish that to you by a greater weight of the evidence? By a preponderance? I mean, there are quick people out there. There are people that are very fast, but that's like lightning fast. 6 shots to the back. The bottom line, ladies and gentlemen, the physical evidence just doesn't line up for them. It contradicts everything that the defendant claims happened in that doorway. It just doesn't make sense. Play lights video. Remember what the defendant told you after the shooting, the priorities were? Make the house safe. Make the house safe. And by the way, he supposedly first is inquiring, why is a man coming into your house with a gun? Did you hear that from Ernest Payne? No. Ernest Payne said they pointed a gun at me. I'm holding my 3-year-old daughter, and they said, get on the floor. Did you hear that from Sharon Payne? No. Ernest told you, because Sharon was obviously tunnel vision. You know, Ernest said, she was right next to the guy, to the marshal with the gun, and he's telling her, get back. You know, and she's not paying any attention. But it's not, why is somebody coming into your house with a gun? You heard at the end of the 911 tape. You hear the marshals. And did they seem concerned about who is this guy that came into your house with a gun? No, they're herding them out. They're pushing them out of their home. Sharon Payne told you she went to or headed to her closet to get a coat. It's December. You know, she's got small children, to get coats for them. They wouldn't even allow that. Get out of the house. Get out of the house. We got to make it clear. And the defense says, yes, that's the priority. We got to make it clear. We got to clear the house. Well, let's see how much of a priority it was for you. We need the computer here, please. Okay, stop. This is Officer Sam Rippey's body cam. You'll have the whole body cam back there, but Officer Rippey is one of the first officers to arrive there, and he's moving forward with his gun drawn. He doesn't know what's going on. Because guess what? One of the practices and principles of policing, communicate. It wasn't happening. It didn't happen. I guess clearing the front yard was important. I mean, that's the defendant. And they haven't cleared the house yet. Okay, go ahead. Let's see what he does.
Okay. We got a medical scene, but...
Yeah, I know, that's what I said. Don't send it in yet.
Okay.
The medics are there. Help is there for Casey. And what does the defendant say? Hold the medics. Because the house isn't clear. Okay, go ahead.
Tell them to stay. Tell them to stay. Come out this way, folks. Come.
He'll keep getting his sleep. But do you notice the change in the taillights? Back it up and play it again. The defendant's getting into his truck.
Come out this way, folks. Come out. Hey, come out this way. We'll send them.
Now that sure was a priority, wasn't it? Better get my lights on. House isn't cleared. I just shot a guy 6 times. He's lying on the floor, dying. And the defendant's out turning on his lights. How's that a priority? Mr. Schroyer asked him about it. Oh, I don't remember doing that. He had 0 explanation for it. Physical evidence doesn't lie. People do. Where else has the defendant lied? Well, I just strike that. I'm not gonna call him a liar, whereas else has the defendant been deceitful. Well, we've seen over and over again the intersection at Ferris and Carl. I think it's important that you remember that the defendant provided a statement to investigators. And in that statement, he said, or wrote, as I was sitting at the light at Ferris and Carl, I see this car approaching southbound. He stops because there's northbound traffic coming through. And as he stopped at the intersection, I see him waving a gun. And as he stopped at the intersection, I see him pointing the gun at the car proceeding through the intersection, the northbound car, tracking the driver. And that alarmed me. And then, once the northbound driver cleared the intersection, he then turned left in front of me. And as he came by me, he pointed the gun at me. Then he drove on. That's what he told investigators through his written statement. You've watched that Ferris and Carl intersection video time and time again throughout this trial. Casey never stopped. It was a continual left turn. What's the defendant's explanation? Oh, well, I was wrong. I guess he didn't stop. Now that he's confronted with the physical evidence that doesn't lie, he's got to back off. But I still saw everything that I saw. In fact, as he went by me, I ducked and I reached for my gun. Okay, there's the left hand. And I'm narrating on the radio, handheld. There's the right hand. What's he driving? What's he turn around with? But that's not all that exists in this case to show you the fabrication at that intersection. You heard yesterday from Christopher Korn. And Christopher Korn, as we all now know, by happenstance, was in the van immediately behind the defendant. And what did Christopher Korn tell you he saw? That I saw this young man dancing in his car, consistent with what we know, AirPods, playing music. And he said he even looked like he was singing. You wouldn't want to hear me sing. But time and time again, when I'm in the car by myself, I'll sing along with have AirPods, along with the radio. And I'm good then. What's that consistent with? It's consistent with the YouTube music. It's consistent with the AirPods. Now, they're gonna get up here and they're gonna tell you all the reason not to believe Christopher Korn. Because, you know, frankly, they know that if you believe Christopher Korn, then the case is over for them. Because he exposes the cover-up. And it began with when he turned his lights on while Casey was dying on the floor, and continued when he submitted his statement with this supposed pointing of the gun. Because if Casey didn't point the gun at him, where is the risk? Where is the need to the urgency to do anything? If he'd been or followed his training or been properly trained, there wasn't a need. He would have wanted to build time, as Professor Stoughton told you. Create time, create distance. But boy, take out pointing the gun at the intersection and everything collapses. So, what about Mr. Korn's testimony is unreasonable? Well, I think the fact that it came at the last minute, that he didn't make himself known to law enforcement, that's something you can consider. But you've watched this, or you've been here every minute, and every minute you've been here, that camera's been here. They aren't just taking home movies. They're broadcasting it everywhere. And back when this happened, there was all kinds of coverage in the media. So is it that astonishing that this guy says, no, I really didn't want to get involved. Once he realized that there was something there, that he'd seen something of importance, because initially he didn't know. He turned around and followed the defendant in Rosser because he's a little ghoulish, I guess. You know, you think, oh, they must be going to do something. Maybe I can be a little entertained. Maybe I can see somebody's door get kicked in or something like that. You might not choose to do that, but you know, there are people that chase fire engines. There are people that have police scanners, and they're listening all the time to the activity because they find it interesting. But once he figured out that, oh my goodness, I was right in the middle of this. Is it astonishing that he didn't want to be part of it? But yet, he also recognized that he did have an important piece of information. So, when asked, why did you come forward? He said, I just had to do the right thing. I had to do the right thing. And it was the right thing. He wasn't obligated to come forward. He did nothing wrong. You witness a bank robbery and watch the robbers jump in the getaway car and drive away. You're not obligated to follow them. You're not obligated to stand around there and wait until the police came and say, hey, I saw the robbers go that way. You're not obligated. We hope citizens will inform the police of information. It's helpful, absolutely. But but it's not an obligation. Despite what Mr. Nolder would make it sound like. Now, Mr. Nolder is a very skilled lawyer. And I think if you watched the cross-examination, you saw a skilled lawyer at work. Because Mr. Nolder said, well, you wanted to do the right thing. Was it the right thing to take down your Facebook? And Mr. Korn said, well, I suppose not. Nothing wrong with him taking down his Facebook. I'm a technological caveman. I'm not on social media. I don't know any of that stuff. Got to call my 7-year-old granddaughter to find out. But it makes perfect sense to me that once you got a hold of his name and broadcasted it throughout the whole area and so forth, and he opens up his Facebook, and here are 100 or more friend requests from people he has no idea who they are, that he'd think, man, you know, the easiest way to stop this is take down my Facebook. So was it the right thing to do? Depends on your perspective. Was it the wrong thing to do? No. There's no obligation. Mr. Nolder made it sound like it was an obligation. Mr. Nolder made it sound like he was doing something wrong. He did nothing wrong. He took his Facebook down. He had made a number of posts, apparently, and I had to call my 7-year-old granddaughter to find out what all that meant. But I guess on the news or on the internet, you have the ability to post, write a comment or put a thumbs up or, something like that. And he did that. And then he took them down. Because shockingly, as he was progressing through this as to whether to come forward or not, he began to have second thoughts. Mr. Nolder made it sound like, oh, wow, that wasn't the right thing to do, was it? No, I guess it wasn't. But it wasn't the wrong thing either. It was a reasonable thing to do, given the situation. Does it mean he didn't see what he saw? Does it mean that he came in here and fabricated all that? Who's got the motive to do that? You got contrasting stories. One person says he's got a gun in his hand. The other says, I saw no gun. I saw nothing in his hands. My attention was drawn to him because he was dancing in the car and he was somewhat erratic. I thought at one moment that he was going to hit me. That's what was notable to me. Who's got the motivation to do that?
Councilwoman approach.
Could you switch us over to the computer, please? much to your relief, I'm almost done. There's a lot more I could say. Remember, back in voir dire, we talked about why did this happen? Why? And I said, you know, you may end up at the end of the case still asking that question, and it may still be unanswered for you. Because that's not part of our obligation. We don't have to prove motive. But ladies and gentlemen, the defendant told us why this happened. I want to play it for you now.
He came out the street, gun in his hand, going to the side door, going in with you guys were pulling out? Yes, as I was pulling up. Yeah, Joey asked for us to go to this. Who's in charge here? I was one of the initiators.
Does that sound like someone who, like a objective, reasonable officer? No. He's going in the house with a gun. I had to stop him. There was nothing that he had done that indicated that he needed to be stopped. Especially when you eliminate his manufactured reason initially to be looking at it. No one saw a gun except the defendant until it was on the floor at 3996 Estates Place. No one, not Officer Rosser, no one. Why didn't they? Because it was in his holster. Ladies and gentlemen, consider all the evidence, evaluate it, and return a just verdict for Casey, who did nothing wrong, but had the terrible misfortune of crossing the path of Michael Jason Meade, an aggressive, arrogant, and remorseless officer who sat before you and told you what disturbed him wasn't taking an innocent life, but that he ruined his son's birthday.
Ladies and gentlemen, we're going to take our morning break. Do not discuss this case among yourselves. Do not permit anyone to discuss it with you or in your presence. It is your duty not to form or express an opinion on the case until it is finally submitted to you. About 15 minutes.
All rise. You sit in their chair.
Everyone can have a seat. Ladies and gentlemen, I was looking around the gallery and I noticed a bunch of people wearing pink clothing. So I forgot to wish you a happy Valentine's Day to everyone. Any closing argument on behalf of the defense?
Yes, Your Honor. May I proceed?
Okay.
Thank you. May it please the court, Madam Court Reporter, Mr. Nolan, Jason, Ms. Stevens, prosecution team. Good morning, ladies and gentlemen of the jury.
Good morning.
First and foremost, I want to thank you. I want to thank you because you started this process by raising your right hand and taking an oath. And that oath was that you wouldn't draw any conclusions or make any assumptions or talk about the case or deal with the case until you go to deliberations. I've been busy, but I've tried to watch you, and I do believe you kept that oath, and I thank you for that, because without you keeping that oath, and without you participating in civic duty, we wouldn't have the best criminal justice system in the world. So once again, I thank you. December 4th, 2020, ladies and gentlemen. It's a tragic day. It's a sad day. It's a tragedy that affects this courtroom, ladies and gentlemen. It affects this side of the courtroom. It affects this side of the courtroom. Somebody lost a son and a grandson, a brother, a friend on December 4th, 2020. Somebody has to deal with the sanctity of life and the preserving life versus the occupation. And December 4th, 2020, ladies and gentlemen, also will affect you if it hasn't already. You'll take a piece of that with you for the rest of your life. Everyone in this courtroom is going to take that with them and say, geez, December 4th, 2020 in the future. Okay? And own that, because you're human beings. It affects people differently. The judge told you in the beginning we have a job to do. The different jobs associated with us. Your job's just getting ready to get started, the hard part. So in order to do that, ladies and gentlemen, I'm going to go over our case and our witnesses' credibility versus the government's case and the government's witnesses' credibility. And I'm going to draw the distinctions. I'm going to point out the consistency and corroboration, ladies and gentlemen, with our case and with Jason Meade. So let's start right there, okay, with Jason Meade. Tour in Iraq for Lima Company after 9/11. Honorable discharge. A pastor, an employee of a government in law enforcement for 17 years. Now, let's compare what Jason Meade perceived that day versus Jason Meade's statement that he gave 2 weeks after the December 4th, 2020, without seeing videotapes, without seeing body cameras, without seeing anything, because he gave his side of what he remembers. And let's compare that to the physical evidence, and let's compare that and see where there's corroboration and there's consistency. Remember voir dire, we talked about credibility. Credibility. I talked to you about it, I said, yeah, if something's corroborated, if something's consistent, that makes it credible. Well, ladies and gentlemen, credibility and corroboration is not a coincidence. It just doesn't happen by luck. So let's go over the points that Jason Meade put out in his statement that have been corroborated and confirmed and occurred. First one, geez, I'm at the intersection, okay? And that's what this case is about, ladies and gentlemen. The interaction between my client and Mr. Goodson, from the interaction to the door. All the other stuff are distractions, ladies and gentlemen. So what does he tell you he sees at the intersection? I'm at the light, okay? I see a car coming. I see a person waving a gun. I see that. So what does he do, okay? So the issue is, do you believe, more likely than not, that my client saw a gun at that intersection at Carlton Ferris, okay? So how is that corroborated? Well, geez, he describes it in a statement, ladies and gentlemen, as an extended mag. I could see an extended magazine. Someone who's trained on arms, someone who's trained on those types of things,
And they're trained, ladies and gentlemen, to look for the unexpected. They're leaving, they're clearing the scene. He's trained, he sees a guy waving a gun, that's not normal. Doesn't matter what time of day or anything, that's not normal. He watches that. So how is that confirmed, ladies and gentlemen, with physical evidence? There's a gun found at the scene, ladies and gentlemen. It's there, out on the body. The government confirmed it for us because they put the Casey gun owned, and certified it, authenticated, that in fact it was an extended magazine gun. Corroborated? Yes. Consistent? Yes. What does Jason Meade tell you, and in his statement, about what does he do when he sees it? He airs immediately to his team. He communicates with the only device he has with his walkie-talkie and tells them, I got a guy waving a gun. Okay? He immediately does that. Now, is this corroborated and confirmed? Who? Yes, Deputy David Youngless. I'm at the Wendy's. I hear the call, guy with a gun. He says, Jay, is it our guy? No, it's not. Why? Because Jason Meade had dealings with Mr. Barber before. Okay? So, guy with a gun, waving. Where are you? He gives a site. And we know that happened, ladies and gentlemen. We know that it happened because they all respond. So, when Jason Meade puts in a statement that I aired over the walkie-talkie, a guy with a gun, right there, that defeats any indication that Mr. Merkel would say somehow that this was a cover-up. Because if it's a cover-up, then he must have started it at the intersection. That's how preposterous their case is. That's how desperate they are. That they would term that when he walks out to the light that it's a cover-up. Well, geez, let me think. I'm going to do this in the next 3 or 4 minutes, so I'm going to pretend to air that I saw someone waving a gun. Come on. And it's confirmed by Deputy Youngless. Jason Meade in his statement, the purpose of the statement is to say, this is what happened, this is what I saw. And you heard our, his purpose is to poke holes in that statement. In the statement, he says, when I saw the person at the end of the street, he had a gun in one hand and a bag in the other. Again, somehow Jason Meade is clairvoyant and knows. Now, again, how do we prove that? The government proved it for us with a picture of the bag. Jason Meade doesn't see any discovery. He has no evidence or anything like that when he writes this out. But he says, 2 weeks after, I saw a bag in one hand and that in the other. But the cover-up started at the intersection. He says in his statement, ladies and gentlemen, that I did a U-turn. Is that confirmed? Yes, by the video. Does Jason Meade know when he writes his statement that there's a video? No, nobody does. He does a U-turn to pursue it. Do you think someone who's done a tour in Afghanistan for 7 months for the Lima Company is going to make up the fact that, oh, geez, yeah, I did a U-turn? No. How's it confirmed? Rosser confirms it. I'm sitting behind Jay. I see him turn. I think, oh, geez, he left something back at the scene. Happens sometimes. All right? But it's confirmed by a video and by Ryan Rosser. The U-turn. Next. In his statement, he says, I stop and talk to Ryan Rosser. I stop quickly and talk to Ryan Rosser. He tells you that on the stand. How's that confirmed, ladies and gentlemen? By the video. You see him pause. Even Mr. Cornish, they said, oh, that's where he paused. And he says, guy with a gun. He communicates. He's got to go. He thinks Rosser, Jason tells you, he thinks Rosser hears this because he aired it over the Marshal's channel. Ryan took his communication off. Okay, is that reasonable? Yeah. Does that make sense? Is it confirmation that he stopped and told something to Ryan Rosser? Yes. The video shows that and Ryan Rosser. Confirmation. He tells in a statement, I point to the guy and say, there's the guy with the gun. Who confirms that? Ryan Rosser. Ryan Rosser says, yes, as I pulled up, get my stuff on, Jay, go, there's the guy with the gun. I look down, the guy looks at me. That's confirmed, ladies and gentlemen, and that's consistent. Consistency is not a coincidence. Collaboration is not a coincidence, ladies and gentlemen. Next, he yells. He says in a statement, I issue commands. I yell, drop the gun, show me your hands. He goes, I yell multiple things, multiple times. How was that cooperating? Two ways. Sheila Staniford. So somehow Sheila Staniford hears commands. Show me your hands, show me your hands. 3 times she says. And then she says, I heard shots. Mr. Merkel goes, well, you heard the shots first, then the commands, right? She's like, no. Why would I lie? She heard commands and did that. And he has the audacity to get up here and say this was a cover-up? That, gee, somehow I'm going to pretend that there's a gun up at the scene. I'm going to pretend this, I'm going to do this. Then I'm going to pretend that I yell commands, but yet Sheila Staniford hears the commands. That's how desperate they are. Who else hears the commands? Ryan Rosser. He hears them as he's pulling up in the car, he hears them. Can't tell you exactly, he hears the commands, then he hears the shots. Cooperation, confirmation. Let's go to another topic with regards to credibility, ladies and gentlemen. Credibility, okay? Remember Sergeant Stanley testified at the scene. There was an issue. He's like, hey, talks with the other detectives. We got an issue. We got a magazine that holds 30 on Jason's rifle. We only have six shell casings. Hey, have we missed another shell casing? What have we done? Well, let's ask Jason. Jason, how many do you start with? He says 29. That's a mathematical certainty. If there's 23 left in the magazine, and you start with 29, and guess what? There's 6 shell casings found. And he tells you what? And the people who testify with the weapon, if you pull that trigger on fully auto, you have no idea how many bullets come out. No idea how many bullets come out. One pull, it could be 3, it could be 4, it could be 5, it could be 10. It depends how long. So again, mathematical certainty, 1 + 1 = 2. There is no doubt. And again, you know he's telling the truth because he doesn't know what they're talking about. They ask him a question, hey, how many do you normally start with your magazine? He said 29. There's 23 left, and oh geez, this whole cover-up, there's 6 shell casings left, this whole cover-up. It's a mathematical certainty. Where else is he corroborated? By the physical evidence that doesn't lie. That's physical evidence. 23 bullets left, started with 29, there's 6 shell casings. What else is physical evidence? He tells you in his statement, and he tells you when he testifies where he was approximately when he had to fire his weapon. When the gun came back towards him, not turned all the way around like Mr. Gross, when the gun came back towards him, and there's an imminent threat facing him, an immediate threat facing him, he moves to the left, goes and fires, okay? So he tells you where he is, right? And he tells that in his statement. Geez, where are all the shell casings in those pictures, ladies and gentlemen? They're all to the right. Who confirms that every single person who testified about ejection speaks after? No access to any of this stuff. None. You heard Detective Hughes say no. Consistent with physical evidence. The government helps us and proves one on our own that we didn't even have to worry about. And that's when Mr. Schroyer started his cross-examination of my client saying, you said that a northbound car came through, right? In your statement. My client says yes. Hasn't seen the video, shows it. Mr. Schroyer goes, well, where's the northbound car? Jason goes, it just went by. A northbound car went by before Casey Goodson's car turned in there. Yes. Well, you can't see that on the video. They back up the video and you guys see the northbound car goes, and Casey Goodson goes. They proved that for us. And that was in Jason Meade's statement. How many times do you think the 3 of these people have watched that video? How many times do you think they've gone back and forth? They've clipped it, they've cropped it, they've done it. They put their little circles on it. And Mr. Schroeder was even wrong about that. But yet Mr. Merkel stands up here and says, because Jason Meade said, I was wrong about when the car actually stopped in front of me versus it slowed down and continued turn. I was wrong about that. Is it reasonable? They've had the video for 2-3 years, and he misses that. My client says, yeah, well, I asked him, why do you think you're mistaken? Well, I was focused on the gun. That's why he flinched when he went like this, when he turned to the side. I was focused on the gun. That's their big Perry Mason moment, ladies and gentlemen, that in a 10-page statement, that's the only inconsistency or only thing that's not exact to the video, exact to the physical evidence, from the time of the interaction at the scene until the doorway. Northbound. Jason didn't have the advantage of watching the video over and over, ladies and gentlemen, when he gave his statement. That's why he didn't have that advantage. Mr. Merkel talks about the credibility of Mrs. Payne. We're not, no, absolutely. Mrs. Payne is credible, Sharon Payne. She's even so credible, ladies and gentlemen, that they asked her a question about, well, when he rides, you ride with him in the car, yes. Yeah. Does he have the gun? Yeah, he usually always has the gun with him. Well, it's uncomfortable for him when he keeps it in his holster, so he brings it out. Then they ask, well, does he ever point it? No, he never pointed. But she tells you, she's honest about, yeah, it's uncomfortable. That's why he doesn't ride with it. And then what do we have to do? Because they asked that type of question. Mr. Nolder has to get up here and show a picture of her grandson to someone who just testified, who they just played the 911 call to you, okay? And he has to say, who's this in the picture? That's Casey. Where is he? He's in a car. What's he doing? He has a gun. What's he doing with that gun? He's pointing it. That exhibit will be back there for you. That exhibit. So that's what they do, ladies and gentlemen. Do we think Miss Payne's not credible? No, we know she is. Because she's the one that tells you it's uncomfortable. He doesn't use it. He doesn't keep his gun in his holster in the car because it's uncomfortable. They want to have it both ways, ladies and gentlemen. They want to play on your emotions and play a 911 tape about what occurred after, ladies and gentlemen. Nothing during the intersection until the use of force was done. Nothing. Their whole closing, ladies and gentlemen, was about what was before and what was after. That's not the analysis of this case, ladies and gentlemen. How do we know that Jason's telling the truth? How do we know that he's credible? He was asked, did you put your siren on? No. He was asked, did you put your lights on? I don't know. I don't know. Ladies and gentlemen, someone who is lying tells you, I'm 99% sure I turned my lights on. We asked them, when you were at the scene, did you turn your lights when you were pursued? They asked them, did you turn your lights on when you were pursuing Casey? Because I don't know. Did you turn your siren on? No, I know I didn't turn my siren on. So, a lie, ladies and gentlemen, is, yeah, I'm 99% sure I turned my lights on. Oh yeah, I definitely turned my lights on. Yeah. And then you're shown that your lights weren't on. That's a lie. But when you say, I don't know, that's being honest. Watch the video, the full video, not the cropped one, the full video when Jason Meade goes towards the intersection. You'll see that it's 8 to 10 seconds, depending on how you count. Close your eyes when you go back in the jury room. 1, 1,000, 2, 1,000, 3, 1,000, 4, 1,000, 5, 1,000, 6, 1,000, 7, 1,000, 8, 1,000. Open your eyes and imagine what you see to the left, to the center, to the right, in an intersection at Carl and Ferris. Okay, 8 to 10 seconds. Then write down what you saw without revealing anything. Okay? Everyone will have something a bit incorrect, but the basics will be there. The vantage point of my client was there for 8 to 10 seconds, observing Mr. Woods' car, his attention directed to it, observing him go here, observing it going like this. Once again, they had it for 3 years and they get it wrong about what happens in the video, ladies and gentlemen. The cross-examination of my client was, geez, another Perry Mason moment. Geez, you said today, Mr. Meade, that Casey Goodson was running from you when he was at the car and went to the house. He was running back to the side house. Yeah, I said running. But in your statement, you used moving quickly. There you go, moving quickly versus running. Then they go over and over with Ryan Rosser with regards to him describing how he was eluding or fleeing. Each of them saw what they saw and described, okay? But the issue is, the concept is, ladies and gentlemen, are they confirmed and corroborated that the guy was eluding them, evading them? There's the guy with a gun. Rosser says, I turn, he looks at me, and then he bolts, he flees. So does Jason Meade. Running versus moving quickly. Based on their training, ladies and gentlemen, every witness said this, if someone sees you and knows you're there and they leave, they're evading you. They're trying to elude you. Every police officer said that, ladies and gentlemen, because they're trained to look for that. This case isn't about whether he took his first step. Okay, when they asked Mr. Rosser, how did he take that first step? Did he run? It's a progression, ladies and gentlemen. We just went over, ladies and gentlemen, from the intersection to there, everything that was confirmed and corroborated on behalf of my client's testimony and statement. And yes, by the physical evidence. Now, let's go over talking about someone. Mr. Meade was consistent and credible and corroborated. Outside corroboration, not just himself. All right, now who in this trial could provide you with no corroboration? Who in this trial can give you neither consistency or confirmation? Who in this trial, geez, Mr. Korn, AKA Facebook poster, AKA the deleter, AKA I'm second place with 116 points on following Tamala Payne's we're friends on Facebook. That person. Let's look at him, ladies and gentlemen, and see what corroborates his testimony, if it's consistent. If it's consistent with the physical evidence, as Mr. Merkel says. Well, he was unique because you got an instruction before he testified. That doesn't normally happen. There's a separation of witnesses. You got an instruction because he's watched the trial. He's watched Sheila Steenberg. He's watched our client. He's watched the news. He's watched everything. It would be like taking someone in the back of the courtroom and plucking them in and say, hey, what'd you see that day? That's how desperate they are. That's their witness. They put that type of evidence on. Let's look at just his vantage point. Let's take it there. Forget the other stuff for a second. Let's just take his vantage point, okay? As he pulls up, he's in position 2. He's behind Jason Meade. Now, initially, he tells Mr. Merkel on February the 7th, oh yeah, I saw Casey Goodson's car. How do I use his name, Casey? I saw Casey Goodson's car in the car. He doesn't tell that to the FBI. And he doesn't tell that to you. Mr. Nolder brought that out. Not them, Mr. Nolder. Then what happens is, he's... Now, when you watch the video, use your common sense. Don't leave it in here. Take it back with you. You'll see that his car never actually stops. He kind of rolls, okay? I submit to you, using your common sense, that we have all approached the intersection rolling, and at some point, ladies and gentlemen, your attention's got to be on the car in front of you, so you don't hit it. You got to come to some type of almost stop. So I think it's reasonable to believe that you have to look at the car in front of you, right? And look at his vantage point. Look at his vantage point, okay? And use the counter, okay? Again, your memory will be better than mine back there when you go, but use the counter. When I use the counter, from the time Casey Goodson's car turned on the front of my client's car, 1,1002. Close your eyes. 1,1002. Imagine how fast that is. Look at the video. That's the vantage point. And that's the time that Chris Korn had to see in this situation. But it doesn't really matter, ladies and gentlemen, because he's watched everything else. He's watched everything. He told you he heard about the AirPods. So why would he say that he was dancing and stuff, Mr. Merkel wants to say? Because he heard that. He heard about the music. He saw it on the trial. Look at the 2 seconds. Now, the FBI shows him the video. Mr. Merkel, Mr. Short, Mr. Shaw interview him the day before. They don't show him the video, but the FBI does. Let's just listen to what he says in that video, or that audio tape, I'm sorry, in his tape recorder statement, with the FBI. Well, put yourself in his shoes, ladies and gentlemen. We have that a lot. Put yourself in his shoes. The FBI is coming to interview you. You'll feel nervous. Not every day you're interviewed by the FBI, right? What's he tell the FBI? Well, the guy made a wide turn. Okay. Look on that video. Show me where the wide turn is, ladies and gentlemen. Now they're going to talk about a brick wall. They're going to talk. No. You can see the car turn. There's no wide turn. What else does he say? Oh, geez, he almost hit me. You can't have it both ways. Either he makes a wide turn or he almost hits you. Because a wide turn, you're not going to hit him. And again, 1/1002. This is what he's saying. Okay, this is the time frame. Now, the best one is when he tells the FBI, they ask him, well, how'd you know that these guys were law enforcement? He goes, well, because they had their lights on. He had his lights on. That's a problem at the intersection, because he doesn't. And they ask him, are you sure? He goes, I'm 99% sure that he had his lights on, because that's how I knew. Blue light, this light. Now, after meeting with the prosecutors, he changes that a little bit on the stand. Well, it was a break light. No. He tells the FBI he's 99% sure that the only way I knew they were law enforcement is because Jason Meade had his lights on. The ones above, the ones on the side, and stuff like this. He even talks about that in the interview. Well, are you sure? Then they show him the video. No lights on. And he goes, well, maybe during the U-turn. No. That's their corroboration. That's their witness. He must have only seen the part of the trial where Mr. Merkel showed multiple times of Jason putting lights on at the end. At the end of the thing. After medics are there and everything like that. So, of course, his lights were on. That's why he says it, ladies and gentlemen. He's told about the pains and perjury of talking to the FBI, and you need to be truthful. The very last question is there anything else that you think is important? Anything else that you think? Do you have any contact with the family? Anything else important? This court says nope. Nope. He doesn't tell him that he posts directly instant messages to Malapane 4 times. He doesn't tell him that he comments, likes, loves, things of that nature. Thumbs up. Caring emojis. He doesn't tell the FBI that. He doesn't tell the FBI that he's at 116 points. He's almost a top point getter for 1 week. This is the week of January 28th. That's 3 days before this trial even ever started with evidence. Opening statements were on January 31st, ladies and gentlemen. He's posting and responding to their site on January 28th, 29th, the 30th. He keeps posting the 31st, the 1st, the 2nd, the 3rd. He's ahead of one of the other Payne family members. He's in 2nd place at 116. Now, I don't think I need to say that to the federal government. But that's reasonable, Mr. Merkel says. That's reasonable that he didn't tell them that. That's not doing the right thing, ladies and gentlemen. That's not doing the right thing. Instead, what does he do, ladies and gentlemen? They interview him on the 7th, the prosecutions. He's interviewed by the FBI on the 8th. And what does he do on the 9th, he tells you? Yeah, I'm going to delete everything. I'm going to delete everything. That's doing the right thing. People don't delete things who are transparent. You don't delete something unless it's a problem. You don't delete something unless you're making it up. You don't delete that. You don't delete stuff if you want to be the 15-minute fame. You don't. But now we know why he deleted it, ladies and gentlemen. And again, this is their witness, contradicting himself. He tells Mr. Noller, well, I guess I shouldn't have done that. Really? Do the right thing. Really? let's also look what he says. Now, this gets into the details, okay? Let's take his statement apart. His statement to the three prosecutors and his statement to the FBI. Number one, they said, well, can you describe him? Describe what he looked like. Well, first he says it's a female. And he says, oh, split second. Keep track of the split seconds. Then he says, yes, the person had an afro. You know that Mr. Merkel just showed you that he had a do-rag on. You know from the pictures that he had a hood on. You know that a do-rag can't show an afro. 0 for 1 he is. That's in the first interview. In the second interview, the FBI asked him, well, describe him to us. Well, he had a ponytail. Didn't have a ponytail. Ladies and gentlemen, Chris Korn can't even corroborate himself. He can't even be consistent himself from one day to the next because it's not true. First it's an afro, then it's a ponytail. And you guys know from the evidence, he had a do-rag on. You can't see that. But Chris Korn needs you to believe that. He's got to add those things in there, ladies and gentlemen. Because he's doing the right thing. They know. Now, did they ask him about social media? No. Did the FBI ask him about social media? No. We did. And he knows coming to the deposition on Monday at our office that he's already deleted this stuff. He knows. They're there. They know how biased he is, but they still put him on, ladies and gentlemen. Because their case is terrible. Desperate. He says 99% 3 times in the interviews. The first time is with the lights. The second time is I'm 99% sure that I came back out of states. Oh, really? Tells that to Mr. Merkel. Tells that to the FBI. The FBI then shows him, and guess what? He's wrong again. So far he's used 99% 2 times, and he's been wrong about both of them. So even 99%. Likes, cares, emojis. Now, what was really striking, ladies and gentlemen, was on the cross-examination with Mr. Nolder, okay? This is using your common sense. And the credibility of a witness, that an instruction was given to you, is he says, man, yeah, when I was at the park down on estates for about 10 minutes, give or take some. And he goes, then I looked and I saw this person who scared or spooked me. Ladies and gentlemen, we've all been in that situation where you get scared or startled or you get spooked by something. What do? You then look at it. You then describe it. You then go, oh, geez, that's in later. Mr. Nolder asked him, can you tell me what she looked like? No. Can you tell me what she had on? No. Can you tell me where she was? No. Can you tell me where the car is? No. He can give you no details about that. Now, but the government wants you to believe that, oh, he was dancing and singing and stuff like this, and you can see all that stuff in 1002 with this. What else does he say? Well, geez, there was one hand on the wheel. No, there was no hands on the wheel. There were both hands on the wheel. One hand here. Multiple. But he can give you nothing about the person who scared him, and he was looking at them, and he realized, yeah, that she's taping me. And he's looking directly at them. 0 information. Ladies and gentlemen, the reason we asked him about the post on December 18th of 2020, this is 2 weeks after the incident, 2 weeks. The reason we asked him about that is because it's important. And the reason we asked him about that, ladies and gentlemen, in Mr. Nolder's last question, ladies and gentlemen, his last question to him, tell me in verbatim what the post read. Okay? I said I was there. I was behind Jason Meade. And I saw the victim come by, and I said I followed down the street. I didn't see anything. That's what he posted on December 18th of 2020. That's what he posted. And he deleted that because he's trying to deceive you, and he's trying to hide stuff. And they put him on. And they know it. And Mr. Merkel says that, I think he acted reasonably. Well, if he acted reasonably, ladies and gentlemen, then we've proven more likely than not, we've proven beyond a shadow of a doubt that Jason Meade acted reasonably. Mr. Merkel gets up here and says, I think he acted reasonably. Very important, ladies and gentlemen, are you gonna rely upon the word of Christopher Korn for a surgery for a child or care for an elderly parent? Because that's proof beyond a reasonable doubt, ladies and gentlemen. Is that the type of evidence you're gonna rely upon that's not corroborated, inconsistent, made up? He can't even get it straight after watching the trial, ladies and gentlemen. Is that what you're gonna rely upon in the most important of your fellows? Very important in this case, ladies and gentlemen, what's in the jury instructions versus what's not in the jury instructions. So let's change gear with that. What's in the jury instructions, ladies and gentlemen, that you have and you read is you only are to judge Casey Goodson's conduct perceived by my client from the time of the intersection to the shooting. That's conduct. There will be no whys in there, ladies and gentlemen. There will be, why did Casey do this? Why didn't he abide by the commands? Why didn't he stop after the commands? Why didn't he do something? And Mr. Merkel knows that. He just got up here and told you the whys of the case, like in voir dire. This isn't about why somebody did something. This is about actions perceived, things that are looked at in my client's shoes. They talk about in their opening the whys and stuff like that. There is nothing in the whys, ladies and gentlemen. It's all a distraction, ladies and gentlemen. Everything that he talked about in his closing was before. The dentist, the subway, the commercial driver's license. None of that is known to Jason Meade. This case is analyzed on what Jason Meade saw at that intersection there to the house. It's all distraction because that's all they have, ladies and gentlemen. There's no reasons why a person flees. It's if you see the act of evading. We talked in voir dire about no shoulda, coulda, woulda. I counted 6 times, ladies and gentlemen, that Mr. Merkel said the reasonable officer should have done or could have done in his closing. Well, ladies and gentlemen, the actual jury instruction, you'll have it back there on page 8, says the relevant legal consideration is not what the defendant officer should have known or should have done, but whether the reasonable police officer placed in his shoes could have believed about the situational need to use deadly force. Could have believed. And they still keep doing it. The experts both agreed you can't do shoulda, coulda, woulda. We talked about that in voir dire. And they keep doing it, even in their closing. Kevin Davis puts you inside of Jason Meade's shoes. Jason Meade puts you inside of his shoes in his testimony, ladies and gentlemen. Nothing in the jury instructions will say you're to do it from Casey Goodson's perspective. What was his intent? What was this? What was this? And that's all their closing argument was. Geez, 6 shots. How could safety, how could you? No. That's not the legal consideration. The judge told you there, you can't use hindsight. That's all Mr. Schroyer did with Jason Meade's cross. You didn't tell Ryan Rosser to put a siren on, right? You didn't tell Ryan Rosser to get on the loudspeaker. You didn't do this, you didn't do that. You didn't wait to verify a plate, did you? No, there's no leads in his car, and verifying the plate, it would come back to a female, not a male who's driving it, who's parked the wrong way, who runs to not to the front of the house, but to the side of the house. You didn't do this, you didn't do that. That's their whole cross, ladies and gentlemen. What you also won't find in the jury instructions, ladies and gentlemen, most importantly, that their expert opined on forever, are tactics. You won't find anything in there about tactics, ladies and gentlemen. The word tactic will not appear. You know what else won't appear? Reasonably accepted police practices. Because the judge gives you the law here. You have the law. You have the law on justification and the calculus of reasonableness. You know what's not in the jury instructions, ladies and gentlemen, is what Jason Meade did not say. Did not say. Remember when Mr. Schroyer got up here in opening and he said, silence is powerful. Silence is powerful. And they try to deceive you with the last clip. Mr. Meade's answer, ladies and gentlemen, but for us, we played the whole tape. They played a clip. The question that was asked, that was brought out from the Minerva Park officer, the question that was asked on his body camera was, what was the call? How did I miss the call? That's the question Jason's trying to answer to Officer Phillips. They don't bring in Officer Phillips. That's the question that was trying to answer. We exposed that. We shed light on that. The question that was asked is, how did I miss the call? What was the call? The call was continuously, and he told you, he radioed it at the intersection, the guy with a gun, he radioed it as he was going down States. That's what the call was. Guy with a gun, waving a gun, pointing a gun. The question wasn't, why did you fire your weapon? That's not the question. But that's how desperate they are, ladies and gentlemen, that they have to just give you a clip and say, here's what Jason Meade's answer was, and they don't even give you the question. Mr. Merkel talked about playing fair in Bordier, playing fair. Playing fair, ladies and gentlemen, is when a coroner, who's a forensic pathologist, who's certified, who testified, it is impossible to say which shot was first. Impossible. He gets up here and contradicts with some theory that he believes the first 3 shots were these. It's impossible, the coroner said. But they just keep going. Ladies and gentlemen, Jason Meade told you once he found out that the person who was placed in a situation, who put the gun back towards him, who he shot, was someone's nephew in the house. He told you how that made him feel. He told you that people react differently, ladies and gentlemen, when they're in use of force. Some people throw up. Because he just learned that it was someone's nephew in the house, he thought about his family and potentially lots of his family. And that he just had to shoot someone. And he has to tell his son on his birthday that I was placed in a situation where I had to make a split-second decision. And how's that going to affect my son? Geez, oh my God, I can't believe this happened. And especially on my son's birthday. No. But that's how they twist it. What definitely is in the jury instructions, and you heard it already, is the testimony of one witness, if believed by you, is sufficient to prove, ladies and gentlemen, any disputed fact. Testimony of you, okay? Mr. Merkel's right. There's only one person who saw the gun came back, and that was my client, okay? But that happens in our society, all right? Under their theory, one of us was walking down an alley, and we got robbed, and there was no cameras, no anybody there to see it getting robbed, but I pick out the person, and I say to the police, that's the person. That wouldn't be good enough for them, because there's no other witness to the robbery. One witness, if believed by you, ladies and gentlemen, did the gun come back. He's the only witness that was there in that vicinity when the gun came back. Yes. But that doesn't make it any less credible, ladies and gentlemen. That's why that jury instruction's in there. Ladies and gentlemen, our case was consistent and was corroborated in every aspect. The fairy tale that they want to tell you about where the gun was, that there was no gun at the intersection, there was no gun, that type of stuff. Ladies and gentlemen, they've put nothing in the record. That's closing arguments. They put nothing in the record disputing that the gun came back. Zero. Not one witness said, in my belief, the gun couldn't have come back. Zero. Nothing contradicts that. Just their creative fantasy arguments. Now, let's look at that. Geez, the holster, okay? 2 people said, Rosser said I used that holster. It doesn't come out. Could come out, why not come out? Hugh says yes. It doesn't matter, ladies and gentlemen, because of physical evidence. There is no blood on the holster. There is nothing there. And think about the clothing that was worn. Okay? There's blood on the gun. Think about the clothing that was worn. Underwear, shorts, pants. Okay? A t-shirt, sweatshirt. You see the picture of the sweatshirt and think, a sweatshirt. It's down here. If the gun, about whether or not, and my client did see the gun turn back towards him. That's a distraction, ladies and gentlemen. How do we get here, ladies and gentlemen? How do we get in this situation? Because the government starts with a premise and works backwards. What do I mean by that? Ms. Stevens told you in her opening that they started from a premise and worked backwards. 6 shots in the back and silence. And Casey Goodson's not a threat. That's what they told that they were going to prove to you, okay? 6 shots in the back, silence, and Casey Goodson wasn't a threat. What happens when you start from a premise and you work backwards, ladies and gentlemen, is you hire an expert after the fact who doesn't know Ohio law, who doesn't tell you definitions, all right? And you indict someone for 3 competing theories, all right? And then what happens in your case is your own witnesses, ladies and gentlemen, contradict your theory of the case. Your own witnesses contradict your theory of the case. So that's their theory, right? He's not a threat, silence, 6 shots, 6 shots, 6 shots, 6 shots. All right, well, who's the first group that contradicts him? Officer Rippey, Detective Williams, Detective Kroon. They all tell you, if you see someone waving a gun, you have a lawful authority to pursue. You must pursue. You must investigate. They all tell you that if you see someone with a gun eluding you, you have to go forward. You have to go forward. They all tell you that their actions as an officer are based on whatever the suspect's actions are. You have to react to the suspect's actions, okay? All 3 of them say that. All 3 of them say, can someone be a threat if their back is facing you and they have a gun? Yes. They're not a deadly threat yet, but yes. And they all told you after Mr. Merkel asked questions, if the gun came back, they even interrupted, I would shoot. They all told you that based on their training, if the gun came back, they would shoot. That goes against theirs. The second person, ladies and gentlemen, you heard them tell about how fast someone can turn. They all said, if someone has a gun and their back is towards you, are they still a threat? Yes, because of the quickness, because of the sudden turns. That's their witnesses. The next one, ladies and gentlemen, is the coroner, okay, Dr. Shepler. Now again, the audacity to say to even give you an idea of which shots are the first goes against 100% of what she testified to. It's impossible, and she's a forensic pathologist. If anyone would know, she would, and it's impossible. Now, it's not that complicated, ladies and gentlemen. You don't need a big demonstration. I asked the doctor, if you're facing this way, and she pointed out the wounds, 1, 2, 2 up here, 2 over here. Those entrance wounds were all what? Back to front, right to left, and upward, correct? So if the body's positioned, doctor, the entrance wounds are consistent with the bullets coming this way. She said, yes. Doctor, you don't know the position at the time, do you? She has no idea, access to discover anything like that. No. You have no idea how the body was positioned. Correct. Doctor, if the body was turned this way, and the same wounds, the same entrance wounds, 1, 2, 3, 4, 5, 6. The same entrance wounds, ladies and gentlemen, was this way. Would that be consistent from the bullets coming this way? Yes, it would be consistent. It's that simple, ladies and gentlemen. And think about it. She doesn't have Jason Meade's statement. She doesn't have anything like that. She has not. It's that simple. Their own witness contradicts their theory of the case. Right to left, back to front, upward. Using your common sense, that kind of matches with what Jason Meade says as a statement, but somehow there's a cover-up. Now the cover-up involves Dr. Shepler and my client on the positioning of the body. My client told you when he was facing away, could you see the gun? No. Did my client shoot then? No. Because he couldn't see the gun. But when the body turned, and my client never said he turned and faced him. My client said he turned. The gun came towards me. Using your common sense, ladies and gentlemen. And don't get distracted by impossibilities. Their own expert, ladies and gentlemen, Mr. Stoughton. They're his words, ladies and gentlemen. They're his words. And his words, ladies and gentlemen, are, if Mr. Goodson did turn and point a firearm, Deputy Meade's decision to shoot was appropriate, reasonable, and consistent with generally accepted police practices. They're his words. He agrees in his report. Now, what does he tell you? but he has to testify for however long, you know, let's see. $3.85 an hour. He's got between 40 and 50 hours, so I did 45. Then he's got 8 hours last week plus travel, so I did 8, 9. Then he's got 8 hours yesterday and travel, that and that. So that's about 70 hours. And you times that by 385 and it's $26,950 to tell you that. He's not an expert in Ohio, never trained anybody in Ohio, doesn't have any police training in Ohio. Compare that with Kevin Davis, 33 years as a police officer in Ohio, OPATA certified, trainer of the year. Thousands of people he's trained on use of force and deadly use of force. Kevin Davis definitely knows the definition of deadly force in Ohio. This guy comes from another state and says, sorry, I'm in Ohio, can't do it. I don't know the Ohio definition. You don't take the time to respond to my partner. You don't take the time to look up the definition of deadly force in Ohio. That's their expert. Not me. No, that's not what I can't do that. I can't do that. He was retained after the indictment, ladies and gentlemen. And he gives you no evidence contrary. They were waiting for it. Oh, I have this, I have something from the coroner, I have this picture. He goes, so there's a factual dispute. And his big factual dispute is Jason Meade didn't stop. Jason Meade said Casey Goodson stopped at the intersection to let the car go by, and he didn't stop. Whoa! That means the gun didn't come back. Jason Meade, no evidence contrary. That's what happens when you start from a premise and you work backwards. What also happens, ladies and gentlemen, is you stand up in closing like Mr. Schroyer did and you talk about locking the car. You talk about, Casey Goodson got out of the car and locked the car. That's why they ask the questions about, hey, the car can't lock remotely to the family members. The keys did that. What shred or scintilla of evidence did they put forth saying that Casey Goodson locked the car when he got out? None. That's how they do it. That's how they roll. They put zero up there. What happens when you start with a premise and you work backwards? You have three competing theories: reckless, knowingly, purposefully. I'm not sure, ladies and gentlemen, how I can have a reckless thought and a purposeful thought, intent, because they have to prove the intent. Those are the three elements of in play here, ladies and gentlemen. The three elements. Let's look at recklessness. Was Jason Meade reckless at the scene, at the intersection? No. Did he fire his weapon there? No. Did Jason Meade fire his weapon when he saw Casey Goodson at the end of the street? No. That would be reckless. Did Jason Meade fire when Casey Goodson was going away from him and he was pursuing him? No. That would be reckless. They have proven beyond a reasonable doubt, ladies and gentlemen, that there's 3 holes in the door. They have proven beyond a reasonable doubt that the floor plan of the panes. They have proven. What they've also proven, ladies and gentlemen, is that this is a sad case. It's a tragedy. Goes without saying, right? We talked about this in voir dire. It's going to affect you. Absolutely. And what did they do? They, ladies and gentlemen, they first start, and you're told in the jury instructions, ladies and gentlemen, that you can't use sympathy. Okay, good luck. That's what you're tasked. You're tasked to be a clinician back there. Who was a clinician? The coroner. She was almost giddy going through the paths and the bulls and stuff, but what did they do? First, they start with a picture of the front and back, entrance wounds and exit wounds. And then what do? They go over all 6 entrance wounds and all 3 exit wounds, and the fragments and everything like that. Okay, people start to get emotional. Okay. Then what do? They do the side view. 6 entrance, 3 exits. And they do the exact same thing over again and over again. People start crying in the courtroom, of course. It affects you, of course. Then what do? They take it to another level and they put the pictures, the more people start